Assalamualaikum warahmatullahi wabarakatuh. We now in the topic of nullity of marriage. The learning outcomes for this topic are at the end of this topic, students are able to explain nullity of marriage, differentiate between void and voidable marriage, and also apply legal principles relating to nullity of marriage to solve disputes in family law. For introduction, there are two kinds of defective marriages under the Law Reform Marriage and Divorce Act 1976. There are void marriage and voidable marriage. For void marriage, the marriage never existed at all, meaning that it is void from the beginning. For voidable marriage, the marriage which are originally valid unless the court declares otherwise, meaning until a decree of nullity is pronounced, will be void. Benefits to know the void and voidable marriage are to clarify doubts, to get maintenance for the woman, and to get ancillary orders. For jurisdiction of court, under Section 67 of the LRA, the Malaysian court have jurisdiction to issue the annulment of marriages under the following circumstances. Marriages registered or deemed to be registered under the LRA according to Section 4, 12 and 26 of the LRA, or the marriage is contracted under any law which provides a monogamous marriages, and both parties reside in Malaysia at the time of the commencement of the proceedings. According to the case of Mahon and Mahon, okay, the principle is temporary absence does not deprive a person of his residence. The facts of the case, okay, the parties were domiciled in Ireland. Immediately after the marriage in Ireland, the parties came to Malaysia and had their matrimonial home in the Federation for 15 years. Later, the wife petitioned for divorce. The High Court dismissed the petition on the ground that it had no jurisdiction under Section 49, subsection 1B of the Divorce Ordinance 1952, as she had been away in Ireland for 15 months of the 3 years immediately preceding the filing of the petition. She then appealed against the decision. Federal Court observed that the learned trial judge had overlooked the fact that immediately after the marriage in Ireland in 1955, the parties had left for Malaya and had for the past 15 years had their matrimonial home in the Federation. Therefore, the judge held that the wife had been ordinarily resident in the Federation since 1955, and as a result, the court has the jurisdiction to entertain the application. We go to the case of Ng Wee Wai and Wong Sok Heng. The principle in this case is the court has no jurisdiction to entertain the petition where one party to the application was not a resident of the place where the application was made. The facts of the case, the petitioner husband, a Singaporean, was married to a Malaysian domiciled in Singapore. The couple was married under the Women's Charter of Singapore. After the marriage, the wife lived with the husband's family in Singapore for a few weeks. Later, she left the husband to return to live in Penang with her family. The husband petitioned to annul the marriage on the ground that the wife refused to consummate the marriage. The court held that the husband could not petition for nullity of marriage as both parties do not reside in Singapore, as the wife was not residing in Singapore at that time. The court referred to Section 80, subsection 2 of the Women's Charter, which is in pari materia with Section 67 of the LRA. Okay, a void is said to be void if at the time of the marriage either party was already lawfully married and the former husband or wife of such party was living at the time of the marriage and such former marriage was then in force. Next, a male person married under the age of 18 years or a female person who is above 16 years but under 18 years married without a special license granted by the minister. The next point is the parties are within prohibited degree of relationship unless the minister grants a special license. Or the last one, the parties are not respectively male or female. Okay, a marriage is voidable. It can be held voidable on the following grounds. Okay, the first one, that the marriage has not been consummated owing to the incapacity of either party to consummate it. The second one, that the marriage has not been consummated owing to the willful refusal of the respondent to consummate it. Next, that either party to the marriage did not validly consent to it, whether in consequence of duress, mistake, unsoundness of mind, or otherwise. Next, that at the time of the marriage, either party, though capable of giving a valid consent, was whether continuously or intermittently a mentally disordered person within the meaning of the Mental Disorders Ordinance 1952 or such kind or to such an extent as to be unfit for marriage. That at the time of the marriage, the respondent was suffering from venereal disease in a communicable form. And the last one, that at the time of marriage, the respondent was pregnant by some person other than the petitioner. Okay, we will look at the differences between void and voidable marriage. For the status of marriage, in void marriage, the marriage has never taken place. Okay, it is a question of law and therefore a decree is not necessary. Meanwhile, for voidable marriage, the marriage is valid. The marriage it is valid subsisting marriage until a court of competence jurisdiction pronounces a decree annulling the marriage. It is a question of fact. For the items party entitled to petition, for void marriage, third parties beside the parties to the marriage and any party to the marriage can petition. The valid marriage can be challenged at any time, whether during or after the lifetime of the parties to the marriage. For voidable marriage, only the party to the marriage can petition for annulment of marriage. The validity of the marriage may be challenged only during the lifetime of the parties to the marriage. Next differences, consequences of the marriage. For void marriage, once the decree of nullity has been pronounced, it shall act retrospectively and the marriage will be regarded as never having taken place at all. While for voidable marriage, once a decree of nullity has been pronounced, it shall not act retrospectively and the marriage will be regarded as having been annulled effectively on the date of the grant of the petition. For the status of parties in void marriage, the parties of the defective marriage shall gain the status of a feme sole once the marriage is declared as a nullity. For voidable marriage, the parties of the defective marriage shall gain the status of a feme sole once the marriage is declared as a nullity. There are various grounds for void or voidable marriage. For void marriage, the provisions involved are Section 69A, B, C and D, Section 22, Subsection 4 and Section 72 of the LRA. Meanwhile, for voidable marriage, the provisions involved are Section 70A until F of the LRA. Okay, for the matter of status of the children, for void marriage, the children shall be treated as the legitimate child of his parent if at the time of the solemnization of the marriage, either or both parties reasonably believe that the marriage was valid. There are conditions under this situation. The first one, children born after the appointed date. The second one, father of the children has a Malaysian domicile. For voidable marriage, children shall be treated as the legitimate child of his parent if at the time of the solemnization of the marriage, either or both parties reasonably believe that the marriage was valid. There are also certain conditions, okay, for this situation. The first one, children born after the appointed date. Father of the children has a Malaysian domicile. Next differences is regarding to bar to relief. Under the void marriage, the LRA is silent as to any bars to relief where marriage is void. According to the case of Kobert and Kobert, knowledge of the fact that the marriage is a void marriage by one or both parties to the marriage is not a bar to the petition of a void marriage. For voidable marriage, under Section 71, subsection 1 of the LRA, the court shall not grant a decree of nullity on any of the grounds of nullity of marriage under Section 70. If the respondent satisfied the court that A, the petitioner with knowledge that it was open to him to have the marriage avoided, so conducted himself in relation to the respondent as to lead the respondent reasonably to believe that he would not seek to do so, and B, that it would be unjust to the respondent to grant the decree. Under Section 71, subsection 2 of the LRA, petitioner's knowledge of the fact that the respondent is suffering from venereal disease in a communicable form under Section 70E, or that at the time of the marriage the respondent was pregnant by some person other than the petitioner, under Section, we are referring to Section 70F, would be barred to relief on the ground of voidable marriage under Section 70E and 70F of the LRA. Move on to void marriages. LRA provides that a marriage is void on certain prescribed grounds. Parties of a void marriage are free to contract a subsequent marriage without it being necessary to get any decree. In the case of a void marriage, a decree of nullity can only be declaratory and cannot affect any change in the status of the parties, but there may be reasons for obtaining such a decree. The reasons are there may be some doubt whether on the facts or law applicable the marriage is void. For example, if none of the parties is already married, a decree of nullity is a judgment in rem, therefore no one can allege that the marriage was in fact valid, or maybe one of the parties may present a petition in order to obtain a property adjustment order or financial provision for his or her children. Okay, now we go to grounds for void marriages. Section 69 of the LRA lists 4 grounds for a void marriage. The marriage has to take place from the appointed date, i.e. 1st March 1982. The grounds are: the first one, marriage during the subsistence of a valid marriage. At the time of the marriage, if the party was already lawfully married and the former husband or wife of such party was living at the time of the marriage, and such former marriage was then in force. The case to be referred to is PP versus Rajapan. The principle in this case is the court has no jurisdiction to entertain the petition as the act of bigamy was not committed in Malaysia. If the court has jurisdiction to entertain the petition, the second marriage will be held as a void marriage. In this case, the respondent married the petitioner in India in 1947 according to the Hindu custom. In 1954, the respondent and children migrated to Malaysia. Their marriage was subsequently registered with the Registrar of Marriage in Malaysia. Then in 1988, the respondent went to India again and in March 1984 contracted a second marriage with Saraswati, at which time the first marriage was still subsist. In May 1984, the respondent brought Saraswati to reside in Malaysia. The respondent was charged under section 494 of the Penal Code for committing bigamy. The Supreme Court held that it has no jurisdiction to decide on the validity of the second marriage as the act of bigamy was not committed in Malaysia. After this case, there was an amendment to sections 5, 6 and 7 of the LRA and section 494 of the Penal Code, where a person can be charged for the offence of bigamy even if a subsequent contract of marriage was made outside Malaysia during the existence of a valid marriage.